So, why do we want to talk about access to justice, and why now? Having access to justice means that everyone in Scotland, regardless of who you are, can go to court of law to hold public bodies and polluters to account when environmental laws are being breached. But this is not the current reality. It is incredibly difficult to use our legal system. It is complicated, intimidating, and unaffordable. Although the United Nations Aarhus Convention requires Scotland to ensure we all have the right of accessing justice when we need it, the current barriers in Scotland's legal system are in breach of this international agreement. And there has been an inexplicable delay for over 10 years to fix the situation. All the while, environmental issues with deep impacts on people and the natural world we live in are going unchecked. Scotland has been given until 1st of October this year by the governing bodies of the Aarhus Convention to address this. Today, our Policy and Advocacy Officer, Benjamin Brown, will first talk us through an overview of accessing justice in Scotland and what needs to be done to ensure our legal system meets the Aarhus Convention standards. Joining us today are also 3 community campaigners who very generously are giving their time to share their lived experiences of the costs of trying to access justice on environmental issues in Scotland. We first have George Niblock, who will talk to us about his experience with the volunteer-led former Aberdeenshire Environmental Forum. They tried to address the impact of litter on the streets by applying for a litter abatement order, which would have legally obliged the Aberdeenshire Council to address major street cleaning concerns. However, they lost their case and the legal costs forced the forum to close. Then we have Pam Yule and Cass Ray from the Wyndford Residents Union, who will then highlight the importance of legal aid, which has enabled the Residents Union to challenge Glasgow City Council's decision not to require an environmental impact assessment for the demolition of their home, which is 4 26-story high-rise flats in Glasgow. At the end, we'll have time for a Q&A. So please send your questions to me in the chat throughout the webinar, and I'll collate them to ask from the panel. We will not be taking questions directly from the audience today for the purpose of keeping time, but I will be asking them from the panel in the end. So without further ado, over to you, Benji.
Thanks, Julia. And please just bear with me for a second while I share my screen. Okay, can everyone see that all right? Great. Yep. So, hi everybody, I'm Benji. I'm the Policy and Advocacy Officer at the Environmental Rights Centre for Scotland. And I want to set the scene by providing an overview of some of the barriers to access to justice. I'm going to be explaining why this matters, both to environmental protection and also to community empowerment in Scotland. And then I'm going to consider what progress has been made tackling these issues to date. So what is the problem? Well, currently, it's far too difficult to hold the government and polluters to account in a court of law. Access to legal justice is fundamental to upholding our right to a healthy environment. Most of Scotland's environmental problems are the result of cumulative environmental damage over time and a lack of enforcement of our existing laws. And if governments breach their legal obligations, which they often do, then we should be able to challenge them in a court of law. Yeah, our legal system is complicated, intimidating, and expensive. Just think what we could do if we had improved access to justice. More people would feel empowered to act and to exercise their environmental rights. We know that there is huge unmet demand for legal justice on environmental matters, whether that's a loss of green space resulting from poor planning decisions, air and water pollution arising from landfills, sewage, or incinerators, or the ongoing scandal of the breaches to our legally enshrined climate targets. Since the launch of our free legal advice service in June 2021, we've had over 250 inquiries coming in, with almost a fifth coming from the most deprived areas of Scotland. We're Scotland's only legal hub for environmental justice, and we believe that we've only just started to understand the breadth and depth of environmental damage that needs to be challenged in Scotland. Yeah, our barriers to access to justice are stark. We've seen next to no progress improving access to justice on environmental matters in Scotland, and the Scottish Government has been dragging its feet for far too long. The United Nations Aarhus Convention enshrines our procedural environmental rights. All four nations, all four UK nations, including Scotland, are signatories to the Aarhus Convention, which enshrines people's right to environmental information, to public participation in environmental decision-making, and access to legal justice on environmental matters. It's the cornerstone of our environmental democracy, enshrining the procedural element of our right to a healthy environment. The third pillar, access to justice, refers to our ability to hold public bodies and polluters to account in a court of law, and we should be empowered to use these legal mechanisms to secure environmental justice. Yet our government has failed to make this a reality. In October 2021, the governing bodies of the Aarhus Convention made their 10th consecutive ruling that Scotland is in breach of the Convention's access to justice requirements. The UK ratified the Convention in 2005, but it is still in breach of Article 9(4) to ensure that access to justice is fair, equitable, and not prohibitively expensive. Reforms are needed in multiple areas to improve affordability using the legal system, most importantly around legal aid and around court costs. And the committee gave Scotland until October 2024 to fix the problems of access to justice within Scotland. They issued a detailed set of recommendations and required the Scottish Government to produce an action plan detailing how it would address the barriers to access to justice. Yet progress so far has been woeful. So just to provide some more detail on the key issues, the first one is legal aid, which refers to financial assistance enabling people on lower average incomes to access legal services, including advice, mediation, or representation in court. Unfortunately, access to legal aid is currently limited to individuals, which is a problem because environmental cases often impact whole communities when it comes to exposure to environmental harms or environmental hazards. Furthermore, it's often community groups or NGOs who are better placed to undertake legal action to protect the environment or to take legal action on behalf of the wider public good. And this is known as public interest litigation or strategic litigation. Yet currently, these organizations are unable to access legal aid. So what needs to happen? Well, we need to amend Regulation 15 to make legal aid available to community groups and organizations. And this is a matter of urgency that we need to bring in a new legal aid reform bill within the Scottish Parliament to table legislative changes to ensure legal aid is available to all. The other key area which needs reform is legal expenses, and this refers primarily to how court costs are allocated within a legal case. Currently, if you take a case to court and lose, you're liable to pay your opponent's legal fees. Environmental cases heard in the Court of Session, Scotland's top civil court, are subject to legal fees which are unaffordable for most people. An individual bringing forward a judicial review can expect to pay tens of thousands of pounds for their legal representation. And so these exorbitant court costs can often deter legal action from even being taken in the first place and preventing people or organizations from taking forward legal action to defend the environment. You can apply for what's known as a protective expensive order to cap costs in court. And these are introduced in 2013 with the intention of reducing the costs of litigation for environmental cases. Yet these PEOs, as they're known, have been deemed arbitrary and unfair, including by the Aarhus Convention's governing body. In fact, they said they've repeatedly ruled that the protective expensive order regime is not fit for purpose, stating that they introduce legal uncertainty and could have a chilling effect on justice in Scotland. And this is not just some academic exercise. We know from experience the problems with the legal system. One example is a case brought forward by the John Moore Trust in 2014, and their legal action resulted in a combined cost of £690,000. Even after capping costs, the total case cost was £275,000, which is a huge amount of money. So it's clear we need to replace the loser pays rule with a fairer system. We need a radical overhaul of the PEO regime, and we recommend replacing it with a system known as qualified one-way cost shifting, which is similar to personal injury claims. And if you're interested more about that, you can read more in our briefing. But the key thing to know is that it would help make the cost of taking legal action much more affordable. So what progress has there been so far in terms of actions taken by the Scottish Government? Well, the good news is that the Scottish Government have admitted to a breach of Article 9.4, and they've promised action to review court rules, reform legal aid, and remove some court costs. Yet the proposals they've tabled are wholly inadequate. They're too slow and they're too vague. They don't go far enough. When it comes to legal aid, the Scottish Government has committed to introduce a legal aid reform bill by the end of this parliamentary session in 2026. But there's no clear timetable for legislation, and they've yet to publish any details of the bill. When it comes to legal expenses, fees have been removed from the Court of Session, but they remain within all sheriff courts in Scotland. And when it comes to protective expenses orders, which were meant to cap costs, the Scottish Government has tasked the Scottish Civil Justice Council to review these court rules, but there has been zero progress. In fact, we've seen the opposite: missed deadlines, a total lack of transparency, and a refusal to hold a public consultation on court rules, and a clear breach of the Aarhus Convention's public participation requirements. And just to illustrate this inaction, we've developed a timeline so you can just get a picture of some of the key hurdles that we've had to deal with. Ever since October 2021, when there was the first, the 10th consecutive ruling of this breach of access to justice requirements, we've struggled getting information from public bodies, whether that's through FOI requests, through issuing complaints to Environmental Standards Scotland, which is Scotland's environmental watchdog, or through writing for government ministers. And the deadline for publishing the review of court rules has been missed again and again and again. We're now expecting new rules to be tabled in June 2024, but with so many broken promises, it's hard to know whether this is really going to deliver the action and change that is needed. And in our view, it's unlikely without any public consultation and a lack of transparency in terms of how these new rules have been developed. So those are some of the key issues around affordability in the justice system. And I also want to highlight how barriers to access to justice don't matter only for environmental cases, but for all human rights. We know there's a new human rights bill, which is due to be introduced within the Scottish Parliament. And we've been working closely with human rights networks across Scotland to ensure that key reforms and access to justice are introduced, which will protect and enshrine all of our human rights within Scotland. We also contributed to a report which recently was published by Human Rights Consortium Scotland, outlining 13 priority actions which should be taken to enhance access to justice. And I'm going to just show you a short excerpt of the video that we developed with them so you can get a picture of some of the issues which are coming up.
We hosted an event to launch the report, Make Human Rights Justice a Reality. Big purpose of this report is firstly to say we do have an access to justice problem in Scotland, and the report goes into some of the details of the barriers, what do those look like for people, and then it sets out really clearly what those 13 actions are. Many of them are for the Scottish Government, some of them are for other stakeholders as well. But the main point of the report is we need to see action happen.
Access to justice is a fundamental part of a strong human rights framework. And access to justice is about making sure that the rights that you have are real, that they're accessible in practice. The problem that we have in Scotland is that everyone has these rights on paper, but we don't equally have the power to access them. So some people are more easily able to access lawyers, to pay court fees, to make sure that they achieve justice. But others, and there are many others, will struggle. And they'll struggle because our laws and our process are not good enough. So they don't meet people where they need to be met.
The Scottish Government should make sure that everyone is treated equally and their rights are respected.
So the forthcoming Scottish Human Rights Bill is a unique opportunity for us to strengthen our human rights framework, but also to make sure that we add international human rights that we don't already have in Scotland.
The most important thing we can do is ensure that the new Human Rights Bill and those 13 recommendations we talk about in the report are put into practice so that our rights have teeth. There's a huge emotional and financial cost with accessing justice as well. Quite a lot of people have to go through the court system and use legal advice, but this is often not free. It's emotionally taxing to go through this as well, because as well as dealing with the ramifications of what's happened to them after a human rights violation, they then need to put in a lot of the work themselves to find out how to access justice and a route to remedy.
So that just provided a bit more of a detailed overview of some of the key access to justice concerns which which impact all of the human rights that we should have be able to exercise in Scotland. But I just want to summarise by concluding what the key reforms are that we need as a matter of urgency to address these access to justice breaches. First of all, we need to reform legal expenses so that it's affordable for all of us to uphold environmental laws in court. And the key ways to do this are through legal aid reform to make it available for public interest litigation and for communities as well as individuals, and remove the burden so the costs of going to court don't all just fall on one person. And that's also through overhauling the protective expenses laws regime with the review of court rules that I mentioned, so that we have a much fairer system to keep court costs affordable there. We also need a dedicated Scottish Environment Court to cater for the very complex nature of environmental laws in Scotland and address fragmented routes to remedy. I'm not going to go into a lot of detail about this now, but if you're interested, we have another Lunchtime 101 webinar coming up on the 16th of May where we'll be discussing this in more detail. We also need to have an enforceable right to a healthy environment with substantive features defined according to the highest standards. The Scottish Government has committed to incorporating the right to a healthy environment, but these rights must have teeth. And until we have access to legal justice to be able to enforce these rights, then there's no guarantee there'll be meaningful change for people and communities in Scotland. And finally, we need to be able to undertake more strategic litigation. Regulators are often too weak or risk averse at holding public bodies and polluters to account. Only through effectively resourced organisations who are able to take strategic litigation and uphold the law can we ensure that our environment and our natural environment in Scotland will be properly defended. So in conclusion, I just want to highlight 3 calls to action that we have for you if you're interested in supporting our work and trying to hold the government to account to improve access to justice in Scotland. Firstly, you can learn more about access to justice through reading our briefings, reports, and videos like the one prepared by Human Rights Consortium Scotland, and talk about these issues in your workplaces, in your communities, with your friends, push these issues up the political agenda and ensure that the Scottish Government can't turn their eyes anymore and needs to take immediate action. Secondly, you can write directly to the Scottish Government demanding urgent action before October 2024 deadline. And we're going to be sending out a template letter after this meeting to Scottish ministers that you can adapt and send directly to ministers to push this issue up their political agenda, which, given the turmoil in Parliament at the moment, it's easy to see how this could get sidelined, but we know how important these issues are and how they're impacting communities every day. So that's a really important action you can do to help us. And finally, if you have the resources to do so, you can donate to the crowdfunder that will be launching shortly for our new Environmental Law Centre, which will enable us to take our own legal cases forward and directly challenge public authorities in Scotland to improve environmental quality. We've already seen the changes that we can secure through legal action in the recent joint legal case we undertook with Good Law Project, which was trying to get the Scottish Government to publish an environmental impact assessment for its new infrastructure investment plan. And through the credible threat of legal action, we forced the Scottish Government to publish a climate impact assessment. It wasn't good enough, and unfortunately, we couldn't take our case forward because of the exorbitant legal costs. But it just gives us a tiny insight into the types of actions that we could be able to take forward if we had the resources to do so. So that's everything I wanted to cover. I'm now going to hand over to our great community speakers. But if you have any questions, please post them in the chat. I'm happy to respond to them at the end. Thank you.
Thank you, Benji. So yeah, it's a pretty stark picture, but it's really great to hear that there are some truly concrete actions that we could be taking right now, that Scotland could be taking right now to make environmental justice more accessible. So let's hear now from the lived experiences of this system, and over to George on the prohibitive cost of legal action. Thank you, George.
Thank you, Julia. Thanks, Benji, for your clarifications. As Benji indicated, there are many complex aspects involved in taking a legal action and efforts to obtain access to justice. So I've been invited to focus on the potential financial costs in particular, based on the case that I took back in 2018. I was a member of Aberdeenshire Environmental Forum, an organisation established by local councillors some 30 years ago to be the environmental conscience for the council, to be a critical friend. But some number of years down the line, they didn't like the criticism and were unhappy about it. The organisation organised a litter project called Aberdeenshire Litter Initiative. It was the largest adopt-a-street volunteer litter picking project in the UK at the time, with 650 volunteers out picking litter. It was commended by the Minister in the Scottish Parliament at Holyrood. For a number of years, we were unhappy about the state of cleanliness of the council's area and the streets, and we tried every route available to us to achieve improvement, but without success. Legal action was then our only choice, our last resort. The two choices at that time, when there was no Environmental Standards Scotland then, was a judicial review at the Court of Session, mentioned by Benji, horrendously expensive, or a civil case, specifically provided for in the Environment Protection Act 1990, and that took place in the Sheriff Court. There is a section 91 in that Act, which specifically designed for persons aggrieved by the presence of litter and refuse. So it's particularly appropriate to go down that route. And the charity Keep Scotland Beautiful had issued some guidance and advice about how to take such a case. And that inferred it was easy peasy. And the Scots response to that is, aye, right. You can do it yourself, according to that advice, but it was better to have legal advice. Our group had some £15,000 in the bank, which was earned by our members and donated to the group. And we allocated £5,000 to that case, thinking that would be more than enough. As indicated earlier, a civil case of this type can't be taken by an individual. It can't be taken by a group. It has to be in the name of a particular individual. So For my sins, I was the chair at that time, the chairperson, and I got the short straw. I was that soldier, and we played our deck of cards. In the days before the Environmental Rights Centre Scotland were on the scene, we had difficulty in finding a legal team willing to take the case and advise us. Eventually, we identified a team, and we were really pleased with the team and to negotiate a reduced rate because of the public interest that our case raised. The case itself took over 9 months with meetings to be for legal team and 6 individual visits to the Sheriff Court along with our legal team. The Sheriff actually commented during the process that he can do a murder trial in 2 days. Why did it take so long and so many visits for a simple case about sweeping the streets? That's the complexity of the law and the system. We soon used up our £5,000 budget, but once more, our benevolent legal team agreed to complete the action pro bono. That was at the beginning, and no one anticipated so many visits and so many hours committed to the cause. Eventually, as mentioned, the Sheriff declined to issue an order that we sought to have the roads cleaned. Didn't mean to say that the roads were clean, but he just declined to issue an order for a variety of complex legal reasons. Despite that decision, we as a group believed that we had demonstrated clearly there was failure by the public body, the council, and we then applied for the award of our costs. The council didn't apply for costs, but at the hearing in the Sheriff Court again to put our case for the costs, the Sheriff noted that the council hadn't applied and invited them to apply for costs. Of course, officer from the council said, yeah, we'll apply for costs. So both cases were considered. Our application was refused, and the council's application was granted. But the council did not apply for actual costs to the council. And it could be argued they had no extra costs because the same officers were doing the same job. No one had to employ external consultants or work overtime or needed extra resources. It was all done within their current resources, doing their day job. So in our view, there was no extra cost to the council. But what the council applied for was judicial expenses, which at the time were around £170 per hour. The claim for costs for the council officer that was there came to over £10,000. As a local voluntary group with open accounting, with councillors attending our meetings, they knew how much we had in the bank. We openly declared it. We had to settle out of court because the claim was more than we had at that point in time. And our view was that the legal judgment and the expenses claim were both flawed. But we were in the position that we could not afford to challenge that. We had no money left. So as a result of that, our environmental conscience group, and we did more than just litter, we did a whole range of things within the community. We were disbanded, and there was real concern in the group, including significant disharmony amongst the members about the potential financial liabilities on the group itself and on the individuals, with some at that point not wanting to contribute the £10,000 remaining to the paid expenses. The implication was that I would have to pay it personally. So this concern and anxiety was felt no more so than in my own home, where there was some marital stress over that, with the potential financial liabilities of me personally. It's estimated that the overall costs for the case were in the region of £40,000. And that was for a very simple and very obvious failure to sweep the streets, not sweeping the streets, one of the basic services of the council. Very obvious, I'm sure you can all recognise that in the towns and areas in Scotland that you live in, or if you're further afield, it's a UK problem. And it's very obvious that it's been going on for years. You just look at Google Maps, you will see it marked, dated, the photographs where the streets are not clean. Thank you for listening.
Thank you so much, George, for sharing what it means when money is barrier to access to justice and the consequences and real life impacts of that. I'll now hand over to Pam Yule and Kaz Ray to talk about the positive impact of legal aid and what we could do if more people had access to that.
Hello everyone. The Wyndford estate in Glasgow was built in the 60s at a time when architects thought deeply about social well-being and housing that supported and nurtured a person from cradle to grave. Our beautiful Saltire award-winning Wyndford has a wide range of housing, much of it built in the courtyard style with kitchen windows overlooking greens and cars vanished out of sight. Included in the design of the estate are 45,000 square metres of beautiful parkland and mature trees adjacent to the wildlife corridor of the River Kelvin, which hosts badgers, otters, bats, kingfishers, peregrine falcon, hedgehogs, weasels, tons of wildlife and biodiversity. I have seen a deer outside my kitchen window, just a 2-minute walk away from a busy high street. In November 2021, 600 tenants of our 4 26-storey high flats located on our beautiful green space received notice that their flats were to be blown up in a so-called consultation that provided no alternatives to demolition. ERCS initially supported interference through investigating Wheatley's consultation process, which was deemed unlawful by a legal advocate secured for us by ERCS. Their highly manipulative questions gave no alternatives to the outcome that they were promoting. They dangled a decant payment of nearly £3,000 as long as you played ball, and the consultation only went to tenants of Wheatley, ignoring the thoughts of nearly 500 owner-occupied homes and private tenants on the scheme. Inspired by the support of ERCS and other legal, architectural, carbon and structural engineering experts, to start digging, we discovered a Wheatley board report that stated the decision to carry out the demolition had already been made between Glasgow City Council and Wheatley before August 2021, which was a full 4 months before the start of their public consultation. Unfortunately, we were out of time to take this to a judicial review, but if the time limits and raising actions were reformed as ERCS have stated they should be, we could have had a chance to properly challenge this sham consultation. Everything that was followed, including the setup of the Wyndford Future Focus Group, a group of tenants only, again excluding owner-occupiers, who were given Tesco vouchers as payment to go to meetings and decide the future plans for the new development, have all been based on that original unlawful consultation. In early 2023, we decided to pursue a judicial review on Glasgow City Council's decision that an environmental impact assessment was not necessary for the demolitions. I have a quote from one of Scotland's most highly respected architects, Malcolm Fraser, one of the many outstanding architects who supports us. He says, "I can't get planning permission for a teeny wee children's nursery without a detailed swathe of environmental assessments. So the idea that you can demolish 4 26-storey social housing towers adjacent to a residential neighbourhood and an important urban wildlife habitat without one is either wrong or proves that in Scotland rules only apply to the little people and not to the powerful." The thought of a judicial review was pretty daunting. And due to the high cost of funding it ourselves and the loser pays policy would have been completely out of the question without our committee member Kaz being eligible for legal aid. ERCS advocates that community groups and NGOs should be able to access legal aid, and we believe that this is fundamental to environmental campaigns going forward. As Kaz will explain, the application process for legal aid is quite challenging, and if we had been able to go forward as a union, it would have taken a lot of pressure off of just one person. We won our first judicial review and managed to stop the demolition work for a few weeks. Then Glasgow City Council decided once again they would not impose an environmental impact assessment when the demolition started up again. ERCS took us through the process of obtaining another advocate's opinion that their decision was without reason, and we are awaiting the outcome of our second judicial review as we speak. If we win and force Glasgow City Council to impose an impact assessment, the implications are huge, not just for the Wyndford, but for Scotland's policy making around the urgent need to retrofit existing building stock. A radical rethink of the UK's obsession with the wrecking ball is essential to communities' health and well-being and forms an essential part of our right to a healthy environment. Wheatley intends on blowing up 3 of the high flats and top-down dismantling the high-rise closest to residents, it's literally just across the road from hundreds of houses, and then sorting and crushing all the concrete on site for up to 2 years, and then laying all that crushed concrete across our 45,000 square metres of parkland and building hundreds of 6-storey flats and houses on top of this metre-deep layer of concrete. We need to ask, how is it possible that there is no environmental impact assessment required for this work? The high flats represent the interconnection between social, climate and environmental crises that are affecting all of us. Gentrification is not the answer. On the lower floors of the block, small flats could be reconfigured to make 3- and 4-bed apartments, and the upper floors already work beautifully for young people, students, support workers, refugees and the elderly, with resident reps and communal spaces throughout. New housing could be built along Wyndford Road, and all this would be much cheaper and better and avert the environmental catastrophe Wheatley's current plans generate. But Wheatley refuses to even speak to us. We need to ask why are bankers moving into the CEO positions of the biggest housing providers in the UK, and how is it that they are collecting salaries of over £300,000 per annum? Why are they hell-bent on demolishing sturdy quality buildings to replace them with rickety new builds at a huge social, environmental and climate cost? And how come decisions on the future of our housing and green spaces is being made between councils and housing providers behind closed doors and before public consultations are carried out? Huge amounts of public land and buildings are being handed over to profit-making companies for next to nothing, and this is happening right in front of our eyes. Once again, these are national assets being quietly removed from the public realm. These organisations are huge and believe they can do whatever they like with us. So we desperately need a robust, fair, effective and financially inclusive way for communities and individuals to fight back. As a progressive, modern and fair country, it is clear Scotland needs its own environmental court. Thank you.
Hi everyone. So yeah, foreign current and taking on the legal fight for me, I'm positioned in an area in the Wyndford where one of the blocks that is getting demolished is 20 feet from my home. So I have a young son with medical needs and I have some medical issues myself. So I had a personal interest in wanting to take up the case and already been involved with the Community Residents Union and being on the committee. Finding our way, ERCS was our only access. Individually, I wouldn't have been able to access what we've had if I hadn't had the support and knowledge of the group and our link to ERCS, who helped us take things up. Initially, it was a new process and very daunting applying for legal aid. As I have young dependents, my capital that's in my bank is not just my capital. And when we're applying for legal aid, they take all capital into consideration. So I found that very stressful, and we were worrying about having my bank balance the right amount for the application to go through and making sure, even though my income was so low that it merited the legal aid on its own. So that was quite a thing, and if we didn't have the support of legal aid through that, of ERCS through that, and an experienced advocate and lawyer, to take us through the process and to alleviate the worry and the burden and the fear of carrying on with a case at the point of you would pay fees if it went wrong, etc. So that was a huge important thing for us, and to keep going through the process. So we would apply for an advocate, we would apply for an action, and we'd get so far, like we did with the first judicial review. We got to the point of the council were to answer the questions, and they didn't, and they got a £10,000 fine. And then they done a new soft screen and went straight back to it, which was also again an error of the law, which we had to get recessed, and that started another judicial review. And the more that you do that, the more invasive the process is. You stop just sending bank statements and you give historical access to your full bank account. If there's any savings, if there's anything, that is just such a big commitment. But if I hadn't had such a personal investment in it and the support, I can see how it's a huge barrier and deterrent from actually gaining law. Why does the process only go so far without an answer, and then you have to start again and make another whole load of money out of the process? When the soft stip's still going on to the degree it's already having an impact on our environment. Yeah. So I found that really daunting, and still, like, the fear every time of a new case. Will we get there? Will we get the result we want? Did we go through this for nothing? There's plans to do further things on the Wyndford. So where do we go from there? How do we make the legal system accessible and accountable, to the point where we're not wasting money doing reruns, we're not trying to terrorise one person's whole private side of life, as we all consider financially, in banks, and feeling like you're in the wrong for having money that's capital, you know. So yeah, I really believe that from that, and I had wished the whole time through the process we could have had done community legal aid. It's a whole community issue. Fine, I was personally involved in the impact, but the whole community issue, this project contains over 28 serious and dangerous residual risks to health, environment and people's property close by. And for me, that kind of the status of looking for community legal aid on the basis that many people in many ways will be affected, would be a positive step forward in creating people who are willing to speak up for the environmental injustices that are going on with housing and children's areas, etc.